Please be seated. We'll hear argument in 2980, Wal-Mart versus Xerox.
May it please the court, Mr. Melkonian will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. This case, fundamentally from our perspective, is about whether Xerox may escape any responsibility for its own negligence and breaches of contract in allowing the crucial EBT system to go down for 12 hours on a busy Saturday in October 2013. As we'll hear from my friend on the other side, Xerox's theory is that Walmart's only way to protect itself from Xerox's negligence was to stop selling food to SNAP families. That is not what the what the regulations require, and it's not what the regulators want, and it's not common sense. The judgment below should be reversed. My plan is to start talking about the regulatory framework, why the Court of Appeals got that wrong, and how that causes the summary judgments to be reversed. And then I'll go to the individual causes of action, though, of course, wherever the court would like me to go, that's where I will go. So with respect to the regulation does not mean what Xerox wants it to mean, that they have immunity for any act, whether negligent misconduct, recklessness, fraud, or anything else in the context of store and forward. What it means from our perspective is that Walmart cannot recover against beneficiaries of SNAP in a store and forward transaction. And we have several reasons why that's so. And
could it also mean, though, that Walmart is on notice that the program allocated the risk of loss to it rather than to the governance vendor in choosing to sell during an outage? In other words, could it inform the duties and obligations, even if there's no immunity or preemption? It could inform the duties of the parties in terms of risk of loss.
I think theoretically it could, Your Honor, but it doesn't in this circumstance, because I think the text of the regulation alone and the history and context of the regulation suggests strongly that what the kind of risk that's being allocated to us is the risk that there's a outage that's not a cause of negligence, that's not caused by negligence, and then we can't recover against the beneficiaries for the money we lose. There is nothing in the text of the regulation that suggests someone like Xerox is even contemplated by the regulation, or that the duties of someone like Xerox is being allocated. The entire regulation is premised on the question of, can a retailer like Walmart recover against the beneficiary, and in what circumstances?
So your position is that it would not inform liability at all. If we went to a trial in this case, the jury would never hear about this regulation.
Well, they may want to use that as a sort of defense. I mean, I think we would object and say it's not relevant. I can't know what the trial court would do with that. But our position would be that it has nothing to do with whether they have duties to us in tort. That's right. Whether it gets presented to them or not, I can't say. Now,
if we agree with you about what the regulation means, does the Court of Appeals misunderstanding of that sort of infect all of this and send us in the direction of a remand so that this can be reconsidered, without being infected by this misunderstanding of what the regulation means?
Yes, Your Honor, but there's two buckets to think about. The first is the first motion for summary judgment. That applies to the 30,000 transactions that were denied for the invalid PIN or the insufficient funds that were in the count. Nothing to do with the invalid codes that we can talk about later. Now, with respect to those, if you look at the Court of Appeals opinion, the only thing the court says is it's the regulation that allocates responsibility to Walmart. And so I think if you agree with us on the reg, then that's automatically reversed. There's nothing else to do about that. With respect to the second bucket...
Was that the only ground in the trial court for the first summary judgment, the motion for partial summary judgment on those particular claims? Was
we
the
believe it
regulation
was
the only ground?
Yeah, we believe it was, Your Honor. That's the ground that they pressed. I'm not sure what Mr. Cole will say about that, but we believe that was the only ground presented.
So if we agree with your construction of the regulation, we reverse that partial summary judgment as to those 30,000 claims, but we remand Because all we're saying is they're not entitled to summary judgment on that ground. They may yet be entitled on another ground.
Absolutely, Your Honor, and we're perfectly happy to litigate all the grounds, when we get back to trial. As to the second group of 50,000 transactions, that's the subject of the second motion for summary judgment. There, we think that does infect, the regulatory misunderstanding does infect every part of that decision, but the Court of Appeals does also say other things. And so we think you have to perhaps, you probably don't have to get to those other issues, but we think you could theoretically do that. So with respect to negligence, for example, the Court of Appeals says they have no tort duty to us. That one, I think, is premised entirely on the regulation. But then with respect to negligent misrepresentation, the Court of Appeals says, yes, it's the tort duty problem again, but also they concentrate on the testimony of Mr. Howarder, who says, look, Mr. Howarder is a Wal-Mart employee, and he says, no one literally told me to send all the transactions over to Xerox at this time. And he's talking about a particular time during the day of that outage. And our position there is that Mr. Howarder went on in his testimony, and he said, that's because no one does that when you're doing these kind of electronic transactions. What happens is that Xerox flips open a switch, that's called the mini switch, and that is an indication to the retailer that the system is ready to process transactions. So that's a negligent misrepresentation from our perspective. But also there's negligent misrepresentations with respect to Xerox's statements that the system is coming up, and they keep saying the system is coming up in 30 minutes. What that causes is Walmart to stay in store and forward mode in reliance on its belief that the system's about to come up. If they had told us, by the way, we are refusing to switch over to our backup system, and this is going to be down for 12 hours, and you're going to have tens of thousands of failed transactions, we may have certainly had a different view about continuing in store and forward.
I thought your position was that it was not feasible to call the state on all these customers.
Exactly right, Mr. Chief Justice. But the alternative they would have us do is simply stop selling. And that is an alternative that's permitted under the regulations. But it's not the alternative the regulators would want. And it has pretty severe consequences for our customers. I mean, we're talking about people often who are disabled, or they have transportation problems or family issues, and they're in the store with a full basket. And what Xerox wants us to do is turn them away. And we don't think that's the right answer. Indeed,
But there is a reimbursement process, correct? So, but in this case, the USDA denied reimbursement to Walmart.
Well, Your
Does
Honor,
that have significance in terms of looking at the other summary judgment grounds that were put forward aside from the preemptive effect of the regulation?
Your Honor, we actually think that USDA determination helps us rather than hurts us, and let me explain why. First of all, I just want to make a factual point. That letter that my friend on the other side relies on is in reference to a completely different incident, a 2015 incident involving JP Morgan. So it has nothing to do with this case. They're using it as an example of USDA saying, we're not allowed to represent, which is the technical term for that, when there's an outage. But the reason it helps us is that it shows the regulation is limited to reimbursements against beneficiaries. They're saying, look, this was at your own choice and liability. You can't go after these people for money that's in their account now. And we completely agree with that. That is how the regulation works. But that letter does not say that Xerox is immunized from all liability, or that you have no other remedies, or you can't do anything about it. That letter is just exactly consistent with our theory of this case. So no, I don't.
Section 274 seems to allocate responsibility to a lot of these different entities, the third-party processors, all these characters. And so when in 274.8E, it only talks about the retailer's own choice and liability, why can't we take that to mean something if that was a conscious choice to not allow liability to be expanded to others like Xerox or
Sure.
others?
I think two answers to that, Your Honor. First, I think if you were doing the kind of immunity that Xerox wants you to do, first of all, you run into my preemption argument that we've made in our brief. And so that's a serious problem. We can talk about that. But also, I don't think those are the words you would use to create blanket immunity for even fraudulent misconduct, which is what Xerox's position requires. I think you might say Wal-Mart or the retailer has sole and exclusive liability. No other party shall have liability for any reason. You might even use the kind of words that we heard in Ray Academy that was decided a few terms ago. No cause of action shall be maintained for any claim relating to liability arising from a store and forward transaction. But none of those words were used. This just says no choice in liability. And so the court's task is to figure out what liability means in this particular context. And I would point the court to the last sentence of E1, which is the sentence that explains the exception to the general rule. So the general rule is own choice and liability, and then it says sometimes you can recover against the beneficiaries in this circumstance. So that is an indication to me of what liability means in the first sentence. And then if you go back to E2, that's the next subsection, it says there's some more exceptions for how you can recover against beneficiaries, and that's as the states might allow in certain circumstances. So I think if you're reading liability in general, I understand their argument, of course. That word seems broad. But in the context of this particular regulation, and then when you pair it with the history and context of the regulation, I think it becomes clear, at least to me, that liability has this more limited meaning. And then again, we have our preemption problem, where if it is what Xerox wants it to mean, then you've had the federal regulators without any statutory authority whatsoever. The statute that creates SNAP does not say, by the way, we want to immunize people. So without any statutory authority, they're creating a broad immunity for people who aren't mentioned anywhere in the statute. And I think that would be inappropriate. It's another clue this court can use.
It may not create immunity, but does it demonstrate that Wal-Mart is not an intended third-party beneficiary, in connection with this program?
No, I don't think it does, Your Honor. And the reason I don't think it does is because the contracts themselves clearly contemplate liability to the retailer and Wal-Mart. Now, my friend on the other side has 6 contracts that have no third-party beneficiary language. There are 10 where they're just not in the record at all. Those parts of the contract aren't presented. And I think that's just a fundamental problem. But even those 6, and the 3 he has in his bench book, all of those incorporate the Quest rules. And the Quest rules have a specific provision, section 10.3, that contemplate an indemnity to retailers in the scenario of negligence or fraud, that's one of the subsections, or malfunction, which is exactly what's going on in this situation. So I think what this regulation creates is a default that with respect to the internal workings of the SNAP program, Wal-Mart can't recover against the beneficiaries, but then it allows other ways to recover against other parties in the system. And one way is contract. And we think the contract here contemplates indemnity to Wal-Mart. By the way, those indemnities are capped in most circumstances. So I know there's this undercurrent in my friend's arguments that, we could allow a bonanza where people come in and buy all kinds of things and then they're on the hook. That's not happening.
There's some indication that happened at least at a couple of stores.
It happened and we stopped it. At least that's what's in the record. There's not a ton in the record about it. But if that happens, that's our problem in many circumstances, because these indemnities are capped at $40, $25. And indeed, if there wasn't any negligence, we wouldn't have these tort claims. So in that circumstance, there's a very strong incentive for us to stop any kind of overbuying.
Just to be clear, I asked earlier if we agree with you that the own liability language does not preclude liability by Xerox, then we have to reverse, but we should remand on the first summary judgment. If, on the other hand, we conclude the own liability language precludes liability by Xerox, we agree with the respondent here, does that only resolve the first summary judgment? Or does that also resolve in this court the second summary judgment? In other words, in the trial court, was the regulation a ground for the second motion for summary judgment?
It was a ground that was presented, but I think if you go to the Court of Appeals opinion, with respect to at least breach of contract, it would not resolve that, because what the Court of Appeals says for breach of contract is you don't have third-party beneficiary rights. One thing it says is the reason we think that is because the regulation, puts harm on you, but we think that wouldn't entirely resolve it. And we think that would also leave open the negligence and negligent misrepresentation claims at all, because that's not the only ground the Court of Appeals set forth.
Well, and I understand the Court of Appeals, but what really matters is what was the ground on which the motion was based in the trial court, right? Because if there's any other ground that would support the summary judgment that was presented in the trial court, then we would need to affirm.
I think the answer to that question is that there were other grounds asserted in the trial court, but the Court of Appeals only chose one of those grounds on which to affirm, or some of those grounds.
Any other questions? Thank you, Mr. Malconi. We'll hear from the respondent.
May it please the court, Mr. Cole will present argument for the respondents.
Fittingly, I'm waiting for the technology to catch up. Hopefully we won't have an outage. May it please the court. The problem here is not one of interpreting this regulation. It's more fundamental. Wal-Mart just doesn't have a claim against us. You can call it tort, you can call it contract, but we don't owe a duty to them, and we didn't cause the damages that they're trying to recover in this case. My exhibits that I offered to the court yesterday highlight what I'd like to begin with before discussing some of the doctrinal points and points about the record, which is the structure, not of the regulation, but of this business. On the one side, you have the American taxpayer, USDA, Federal Benefits Program. It in turn contracts or works with state agencies to give money to those who need this money, the SNAP food stamp program, and those agencies in turn contract with experts in the IT field, such as us, to go through the computer systems and make them work and handle the day-to-day operations. So you have money, federal money, state money, IT for the states over here. Then there is a gap, and you have over here now at the people who get the money. This side's the givers. Taxpayer gives to the government, goes on down and through the computer systems to the ultimate people that will spend the money. But here on this side, you have the receivers of money. You have the retailers, the Wal-Marts of the world that handle thousands upon thousands of transactions every day. You have mom and pop at the corner. There are hundreds of them all through this state and these other 16 states of all different sizes. They in turn hire IT professionals to help manage their systems and make sure all these cards are processed correctly, all the money goes to the right places, and they have contractual relationships and understandings with them. It's like buyer-seller, it's like it's giver-receiver, whatever analogy you want to use. This is the classic adverse relationship in commercial law. One side is giving money, one side is getting money. Both sides have people on their team. They're the agencies that in turn use other agencies that in turn use their IT people. On this side, you have the retailers who use their IT people. What this regulation says, and Justice Bland, I've struggled with a name for it. When you said it's sort of an acknowledgement, I tried to think of a catchy name, and I couldn't. The best name I could come up with for a doctrinal label to put on what this regulation says is reality check. It basically says when you get into this program and you elect to use store and forward, don't forget, Wal-Marts of the world, that this business relationship exists, that you've got your own IT people on that side of the equation, that side of the gap, and you need to get your act together with them for this program to work as speedily and efficiently as it needs to work to do what needs to be done.
What were their IT people supposed to do to countermand the 10 hours and all that?
They could have correctly transmitted the information that we sent them. I mean, we sent them thousands upon thousands of codes, and this is the glory of information technology. You can have, enormous roomfuls of this information, but we sent code after code after code that said, resubmit later. There's a temporary problem, and every single time they changed that code to one of different set of codes, but a code that meant throw it in the trash.
So
they could have programmed them
I
correctly.
hear you saying that your client should win because it did everything right and they did everything wrong, but I don't think that's what's before us today.
No, it's not.
You're not
No.
conceding, are you, the regulation argument that's been presented in the briefs?
I think, no, of course not. The regulation is informative.
Do you
The regulation
think-
sets
Do you
the...
think it on its face immunizes and precludes any claim against Xerox in this case?
I think what the Court of Appeals did with it is exactly right. It said this regulation, as to the risk of not having funds, clearly allocates that risk. That risk is off the table. As to civil tort liability or common law contract liability, it's a relevant consideration. And what the Court of Appeals did was look at the criteria you look at for an implied contract, the criteria you look at for...
It's not your position that the regulation immunizes Xerox against the breach of contract claims that have been asserted in this case?
No, I think it makes it impossible for them to meet their burden of an implied third-party beneficiary.
But it doesn't immunize it.
It's not a magic wand that we wave at the top.
But then, as for the first motion for summary judgment, dealing with the insufficient funds and wrong PIN, do you think it immunizes and precludes any claim against Xerox for those transactions?
Yes, that was the basis of that summary judgment, and that's crystal clear in this regulation. There's room to argue. Remember, there's a lot of people in this pyramid about whether or not they were thinking about liability across the lower levels of the structure, but at the top, on that risk of non-payment, no question, they immunize that. They say, look...
So if we disagree with you, then is there any other ground on which we could affirm the first summary judgment order
So
currently in this court?
So the first motion is based entirely on the reg. The second has a number of other grounds.
So there's not another ground on which we could affirm the first order?
That's it. We got into all of these grounds sort of met each other in the motion for new trial briefing. I mean, they sought a new trial on the entirety of the summary judgment orders. We countered with the full panoply of issues, and frankly, the lines as of the final judgment weren't all that clear. I'd also suggest if there's no cause of action, there's no cause of action. And if, in fact, on reviewing the second set of claims, and you conclude there's no viable contract claim, there's no tort claim, well, there's not a viable contract claim or tort claim no matter what the first ground may be, whether the regulation is extra. In that context, I don't think it's a meaningful distinction, given the nature of the specific grounds. So this USDA letter is a good example of this operation of this structure and some of the concerns that we have and what Wal-Mart did with its system. Why were they doing that? And why were they changing the codes that we were sending them, resubmit later to throw it in the trash? And our expert report goes through that. It had to do with a strategic decision Wal-Mart made about kind of getting in line faster when the system came back online. And they concluded that throwing sets of claims in the trash helped them get back in the game quicker. That had benefit. They did it once, they did it twice. The USDA in their letter says stop doing that, and they kept on doing it. They did it a third time in this case. I doubt they do it anymore. But there is, that shows the operation of the distinctness of the two different sides of this. They have their own reasons for doing what they do. They're free to do that. I mean, if they want to throw some claims off to the side and double down on one way of processing claims, they can try to make some more money, power to them. That's their right. But that doesn't make us their guarantor or make us responsible for that. That's a decision they make with their data person on their side of this business relationship.
Is that a complete answer to Mr. Malconian's suggestion that what you really offered to Walmart was stop selling to people in the SNAP program, or does it not quite get forward?
They could have, well, stop selling is certainly one option, particularly when mobs are running in with grocery carts. Which the record doesn't have a lot about that, but it has some. But yeah, if their system had run properly, we wouldn't be standing here. There might still be some injuries, some damage, but we wouldn't be talking about a $1 million damage claim. They would have had a system that correctly heard, submit later, and they would have done something with that that would have actually been a store and forward proper request. But they just didn't do it. And that was the basis for the the primary basis for the second summary judgment, in addition to arguments about the lack of duty and whatnot, was this expert analysis that went through code after code and said they're just changing what you said. And so I think that if the facts of this were a little different, the equities might look a little less favorably on our side, but when they systematically changed everything that we told them, that's just on them, and that breaks the causal chain in tort, contract, and everything else.
If their system had run properly, in your view, and you sent them the wrong code, would you be liable for that?
So if they weren't changing everything we said, and we had sent a mistaken code on the front end, be a more compelling case for sure, but we'd have to go back and see what would the claim be. Is it a claim in contract? Is it a claim in tort? We don't have a contract with them. We have a contract here. They've got First Data, who's supposed to check for that kind of problem with data. Okay, well, is there a tort claim? Do we have a duty in negligence? I suppose it would perhaps go to how many codes there were, the nature of the error, or something like that. But it would be a hard sell, because there again, while the contract makes it very clear, tort's a little more fluffy there, they've still got their own IT person that can look to see if they're getting junk information or not. So it's possible. I could see the argument better, but it would be greatly uphill, I think, either way, just given the nature of how this works. Continuing on the question of what is the cause of action, it's contract or it's tort, it's one or the other. Is it contract? It has to be third-party beneficiary. We don't have a contract. There's no question about that. This gap is complete when it comes to a direct contractual relationship. And it seems a little odd that you don't have, I mean, we've all seen the classic breach of contract pleading. You breached the contract, Exhibit A is the contract. You're the other party, you owed me these duties, give me my money. They don't have that. In fact, they don't have the contract. The best they have are some snippets that we see in the reply brief and a reference to these Quest rules that are a set of industry standards that some states use and some states do not. But here the Court of Appeals, again, got it exactly right. It looked at the Quest rules, and there is a specific statement in them that closely tracks the language of the applicable federal regulation and says, that's on you. That's your risk. And yes, there is general language at the end about indemnity. Everybody has some sort of obligation against somebody else, but specific controls over general, that's it. Now, whether that gets you to third-party beneficiary status is a whole other question. I mean, Justice Wynn.
In your chart where you've got the USDA on one side and the retailers on the other, you don't have the consumer, the user, that's in the interface between these two.
There were so many of them, I couldn't draw them all in.
Is it their theory that they ordinarily would be able to recover against the consumer, right?
Right,
For
the nature of the
non-payment.
program.
And so is it their theory that they come up to your side as an intended
Yes,
third-party
because
beneficiary that way?
well-
And why is that theory?
so they know that they're not going to get the money from the person ever, because that's why they're in the program, is they have an income problem. So they're always going to be paid by, when you run the card, you know you're getting the USDA's money. So there's a relationship there, and there's an understanding of what the USDA and retailers are going to do with one another. But then you start looking down the list. And so if we work for the USDA and or the agencies below them, make their computers work, does that become a contract with Wal-Mart? That's a tall order. I mean, I can see where could we do things that benefit them? Certainly. We could run our computers in a way that would help them. We could run our computers in a way that hurts them. But that's not our duty under the contract. Our duty is to run our computers in a way that makes the agencies happy. We work for them. And we really don't have any obligation to consider what Walmart's interests may be, except insofar as it runs through the USDA. That's classic incidental beneficiary stuff. That's just trying to inject us as the subcontractor into that relationship, makes us serve two masters, and is the reason why we don't like incidental beneficiaries. It puts you in an untenable situation. Incidentally, the other indemnity provisions that are cited in the reply brief, again, I don't think they get to the level of incidental beneficiary, but they are from provisions in bid documents submitted in connection with this program relating to manual transactions, which of course are not part of this case. Wal-Mart was never going to do that. They're not seeking damages based on that. It's just not something, it's something that might be relevant to a smaller store, but a company of the sophistication and size of Wal-Mart simply was not going to do that. So those have really nothing to do with the contractual relationship at all, much less the contractual relationship that would rise to the level of an intended third-party beneficiary, something other than an incidental beneficiary. A couple of comments on other specific claims. The Court of Appeals, and again, when I say the tort claim, every time in some way they work in the concept that I was talking about with Justice Bland, the reality check. We get to this tort, remember the risk is on you, and the regulation is kind of a shorthand for the overall structure of this whole thing. Negligent misrepresentation has gotten some additional treatment in the briefing because there was some testimony about it that was sort of unique to that claim, but there's nothing unique about it as a claim. The same problem is there about the structure of the businesses. There would still have to be a duty that spanned that gap somehow. The same problem is there with the codes. They're still changing everything we say, no matter what we say to them on the phone. Their computer system's still running in the background, scratching out all our 19s and turning it into goodness knows what else. And that's the end of that before you ever get to that testimony. There is then some discussion about whether there's yet another ground for summary judgment based on whether or not we ever even said anything to them meaningful. And the evidence there, we cite this in the brief, we don't go through all of it except for the flashy soundbite, but it's a couple of different witnesses corroborated by transaction logs. You know, everything these people do is logged, and if you study that, you'll see that there's no basis for the claim of representation either. Now, the stakes, in this case, this is a commercial dispute, two large companies, but the evidence in this record, and this is not idle speculation, this is evidence presented to the trial court when we argued about contract construction and scopes of duty, is this really matters, this separation between the two sides of this business relationship to the Xeroxes, to the contractors of this world. Mr. Froderman's affidavit says it's just not going to work. People just aren't going to do this and contract. If instead of a risk here, you serve all these retailers out here, it's not just Wal-Mart, of course. You can't have a Wal-Mart-specific rule. There are thousands upon thousands upon thousands of these retailers, any of whom could have whatever problem they may have someday. They'll come looking for you. We can't do that. We can only serve one person at a time, and the same is true for any rational actor that would enter this space. It's also discussed at the end of our experts report. It's page 793 in the record. It goes into a little more detail about how the industry expects this to operate, the industry being the data processing industry that we are part of, and why this would be contrary to those expectations. Is Wal-Mart left penniless here? They are, of course, not. The most obvious solution that would have avoided this whole problem is if they had properly programmed their computers and not changed what we had said to them. But there is really not a practical risk.
But another solution, right, would be for them to just wait to send the information to you until the computer system was up again.
Which is what they could have done had their codes been processed correctly. We were
Well,
telling them.
No, I'm talking about before they ever send them to you the first time. Because they say, well, you told us to send them too early with the mini switch and that kind of thing. But that would have been another way to avoid this, right? Is if they had never sent them to you the first time and gotten the code that you said was changed, they only got that when they sent it the first time when the system was down, right?
Right. That goes down the rabbit trail of a lot of different codes at that point in our experts analysis. But you're right. There's more than one way to run this railroad.
Well, and another way to do it would be for y'all to have turned on your backup system.
There's discussion of that in the report as well. There's discussion of whether or not Wal-Mart was using the backup system. It doesn't make any difference, though. If all the codes are being changed, it doesn't matter how many backup systems are on. We could have sent them millions of codes.
But it would have been in your system, so it wouldn't have mattered what they did with it on their end, right?
No. We could have had our system, we could have instantly turned our system back on, sent the codes that we did, and they would have, well, if this, you're talking about, could we have switched the system back on? I don't know what the record shows on that. There is expert analysis about that. That's not the basis for what their model is. They say, here's what the damages in the world that we were in, here's what should have happened, and the difference between that is the way these codes were processed.
I thought there was evidence that there was a backup system for, on your side.
Yeah, there's discussion of that in the expert reports. It's analyzed in the summary judgment briefing. That was not the primary issue that was in front of the court, nor is it the primary issue in the way these parties conduct themselves. If there was a problem here, a bigger problem, if our systems just didn't work correctly, of course, we wouldn't be able to contract with these government entities. There would be repercussions. There are checks on rogue actors and that kind of thing that are separate and apart from the civil justice system. This just isn't a claim. It's just not something that is covered by tort or covered by contract. There's not a duty and there's not a contract. The regulation is helpful background. It's explanatory. It's a powerful statement. It's dispositive on certain claims, but at the end of the day, there's just not a claim here, no matter how much we talk about the regulation. The fundamentals are not present here.
In 274.8E, the reference to host, is that you or First Data or somebody else? The retailer may forward the transaction to the host one time within 25 hours when the system again becomes available.
Yeah, I don't know. The term is in the expert report where all the pictures are, the page that we have in the handout. That discussion defines exactly who the host is, and I don't want to get it wrong.
For purposes of
But
this
regulation,
regulatory
yeah,
language.
it defines it exactly there, and he uses a lot of technical words that I'm not going to get right. But off the top of my head, I don't want to get that wrong. I can just refer you to that page before and page after is where you'll find that answer.
Any other questions? Thank you, Mr. Code. Malconian, you have 5 minutes.
Thank you, Mr. Chief Justice. Let me go straight to this codes issue, because that seems to be my friend on the other side's main counter-argument. He seems to have retreated from the regulatory analysis to some extent. That codes issue, at most, is an issue to be decided at trial. We also have an expert report. And our expert report, this can be found at 483 of the first volume of the clerk's record. It's a report by Ms. Maria Arminio. And Ms. Arminio says that they're the ones who are sending the wrong codes. They're sending the code to tell people to re-swipe your card. And that, in the context of a store and forward transaction, is a nonsense code. Because especially where you're dealing with a 12-hour outage, the customer is long gone. No one can re-swipe anything. And so when that incorrect code is sent to us, to First Data, that gets misinterpreted by First Data and sent to Wal-Mart. But that isn't our fault. That's their fault for having caused the outage in the first place and for sending a code that has no application to store and forward.
So your view is that you've raised a fact issue on producing cause?
Absolutely.
And so that the trial court summary judgment, if it was granted on that basis, the second summary judgment, it was incorrect?
That's right, Your Honor. And they can bring that up as a defense if they want to allocate some of the fault to us at trial because they think our codes are wrong. That's fine. We're perfectly happy to litigate that at trial. But that has nothing to do with what the regulation says or what the basis of the Court of Appeals opinion was, in truth, because that is just the disputed issue of material fact.
On the third-party beneficiary issue, I wonder whether we need to step back and think about, sort of be careful in the way that we conceptualize what these programs are doing and why they're doing the things they do and who they're doing it for. And perhaps we should be particularly hesitant to conceptualize a program like this as existing for the benefit of the vendors. I feel like people might, you go to DC and, the look at who's lobbying for what, you can see perhaps the way the sausage is made that the vendors have a deep stake here. But for a court to say that the SNAP program exists and the government's operation of it through Xerox is done for the benefit of people who sell food as opposed to for the benefit of people who need food, it strikes me as an odd way of conceptualizing what's going on here.
That's fair enough, Your Honor, and I understand the concern there. But I will say that these contracts have specific indemnity provisions that run to us. They say they run to us. And indeed, let me point you to an email in the record that's at the second volume of the clerk's record, 2477, where a Mr. Halter, who works for Xerox, on the day of this meltdown and disaster, as they call it, says, we have contractual obligations to our retailers, and we're going to be asked to pay those. They're capped. He talks about the caps, and they don't apply in every state, he thinks. You know, we can have a dispute about that. But the fact that, in general, the prime beneficiary of the SNAP program is the SNAP recipients does not alter the fact that these contracts have very specific language that gives us an indemnity in exactly these circumstances. And that's how the whole system is contemplated. You have the system here that goes between the beneficiaries and the retailers, and then for the sophisticated parties that we're dealing with in this case have made contractual arrangements between themselves. And we think that those should be honored, as Xerox itself recognized on that day. The other thing I want to point out on this Froderman affidavit, you know, we haven't really talked about it. The fact is the entire record of these contracts is not in the record at all. There's only snippets of each contract. And I fundamentally think that if this court agrees with us with respect to the regulation, you could essentially stop there. You could say the regulation does not mean this broad thing that Xerox says it means, even though they've backed away from that today. In the briefing below, they said that it immunizes them no matter what. It doesn't mean that, and therefore reversal and remand is necessary. And with respect to the contracts, this court doesn't even have to go to the third-party beneficiary question. It could say this is premature to decide this on an incomplete record.
If the whole contracts needed to be included, why not follow something like the rule of optional completeness and introduce them?
Your Honor, that's certainly an option. We understand that. But the one thing I'll say is that we are not signatories to this contract, as my friend on the other side will remind us continually, of course. And we don't have the contracts. Well, they have the contracts. And that's the point this court made in Paragon. It said that the party that has the contracts is the one that has the obligation to put them in. If you don't have the contracts, you can resist summary judgment on less than that. But I don't think you can get summary judgment when you have the contracts without introducing them.
Any other questions? Thank you, Mr. Malconian. The case is submitted. That concludes the cases set for argument this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.